Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Hello, lovely people. Another wonderful Saturday afternoon is here with us. And we're on the Community and the Law program live on BWTV and brought to you by BWF solicitors are trusted partners when it comes to the law. My name is Uriku Frimpon, and I want to welcome you to the show. This afternoon, we're looking at this very interesting topic: British citizenship for children. We're looking at some options and requirements that will be needed to met before one of our children would become a British citizen. Are you ready for this? I am sure we are also very ready right here in the studio, as you are out there, so we can do this together. Our resource person and guest this afternoon is Lawyer Charles Asma from the stables of BWF Solicitors. We're streaming live on Facebook and on YouTube at BWF Solicitors and also BWTV UK. Once again, I said my name is Ulrich Frimpon and welcome to the show. It's a Saturday afternoon. In fact, the very second day, the second Saturday, so to speak, of the month of December 2025. Welcome to the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, I know you are live on there. So, yes, announce your presence down there in the comment section down below, either on Facebook or YouTube, and let's get it together. British citizenship for children options and requirements are the things that we're going to really look at this afternoon. And as I mentioned, Lawyer Charles Asma is with us to help us do justice to this topic. So, with your permission, ladies and gentlemen, let's welcome a resource person, Lawyer Asma. Good afternoon, boss.
Good afternoon, Brakuku.
How are you doing?
By God's grace, we're keeping well.
Well, we thank God for all the mercies He has shown us. Yeah, this afternoon, as I mentioned, you are going to help us look into how we can get British citizenship for our children. You have indicated that we'll be going through the options and the requirements. In brief summary, what are we really going to be talking about?
Yes, so good afternoon, ladies and gentlemen, viewers and listeners, wherever you have joined us from.
Hmm.
Today, we are going to be looking at children and British citizenship, those who are born into it, and those who must have it after they have been born.
Okay.
If you are not born into it, it means you do not, literally, you are not a royal. So, those who are not royals, they have to seek to become citizens.
Okay.
Seeking to become a citizen is called registration to become a British citizen.
Okay.
Is it everybody? How? What are the requirements? This is what we seek to discuss this afternoon. And so, if you have a child born in the UK, born abroad, your own circumstance as a parent, both parents, one parent, how does my child become a British citizen if at the time of birth I or the child's father was not British or settled already?
Okay. So yes, the parameters have been set, and I know definitely you started looking at your circumstances and your situations, and you have all your questions. You can text them to 07399208468, 07399208468, or you can put them in the comment section down below. Or when the lines are active, you can call us on 0208 493 7345, 0208 493 7345. It's a community and the law, and we do justice to all your questions. Lasma, as usual, will be on hand to help us answer that. Nanama has enjoyed the services of BWF solicitors, and Nanama is saying thank you to BWF solicitors. And Nanama says especially Abigail Jan for assisting throughout the application for a successful result. Thank you very much, and thank you, Abigail, for doing what you do. Abigail is one of members, a member of staff, really, who is at the front desk, and they help so very well, and also help with case work as well. So Nanama is grateful, Abigail, and to all members of staff, I want to say thank you for doing what you do. Lord Asma, another positive feedback.
Yes, this is what we pride ourselves in as community lawyers. Every week, every day, every hour, our joy is in the joys of the community and
Mm.
giving people opportunity to share a testimony. And this is coming from our sister Nana Ama. Yeah, the next one will be you, the next one will be somebody else. But regardless, we are saying that once you come to our stables here at BWF Solicitors, we'll sit with you, discuss with you, apply the law with you, and walk you every step of the way till you also have a testimony. Even if you are not ready because things are not in place yet, we'll still be guiding you till things are in place so that you can also have a testimony. Our joy is in your testimony.
Well, you want to enjoy what people are enjoying as well. Please use BWF solicitors for all your legal issues. Fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. You can call 0208 493 7340. 0208 493 7340. Now, those of you who are in Ghana, there's an office in Ghana where you can contact to use the services of BWF solicitors, and it's on 055 589 5959, 055 589 5959. In all emergency situations, you can text or call or send a WhatsApp to 0044 7712 761884. 0044 7712 761884. Or you can send an email to bwfsolicitors uh, at bwfsolicitors.com or admin at bwfsolicitors.com. Visit the website. There are a lot of resources there. You use our social media platforms, X, TikTok, Facebook, YouTube, and what have you. BWF Solicitors, we are there for you. This week, our nugget, there's a bit of information and updates that we would want to carry along with ourselves is the settlement route for children that's been shortened to 5 years. I'll just give you the text and we go over to Lasma to give us some further explanation to this. And the text says that since July 2025, more children and young people can now apply for indefinite leave to remain after 5 years on the private life route instead of the standard 10 years for adults on private life routes. However, children born in the UK can apply for immediate settlement under the private life route if they have lived continuously in the UK for 7 years since birth without prior lawful residence. There are some keywords in here in the very last paragraph, for instance. It says private life route, lived continuously in the UK for 7 years since birth without prior lawful residence. Well, these are the technical bits of the whole thing. So, Lasma, please help us.
Thank you very much, Brakuku. So the nugget looks at a child becoming settled in the UK. We know that a child who is born in the UK to British nationals or national, if at the time of birth the mother or father is British or has indefinite, the child is automatically British under Section 1 of the British Nationality Act. What if at the time both parents are not? Both parents are foreigners, could be skilled worker and dependent, could be student and dependent, PSW, skilled postgraduate work visa holder and dependent, could be anybody who does not have indefinite leave to remain. Both mother and father are foreigners. That means the child is a foreigner. In this case, when does the child get to become or get to have indefinite? So the position before the rules changed in 2025 is that once the child is born in the UK, after 7 years of living in the UK, the child can apply for indefinite after 7 years. In other words, from the seventh year going. Then when the child is 10 years, the child can apply for registration to become a citizen. Because we are talking about settlement or indefinite, we'll skip the registration bit, which will be the conversation for today anyway. So we are looking at a child that was born in the UK, both parents are foreigners with limited leave or no leave at all. Once the child was 7 years, the child could apply for indefinite because the child has become a qualifying child under Section 117D. Now, if the child were to become 7 years for indefinite, is this still the case? The rules have changed so that instead of 7 years, it is now 5 years. So that if you gave birth to your child in 2020, whilst you were a student, and after student you apply for postgraduate, and you switch to skilled worker, and now they are saying that everybody on the skilled worker care especially will have to wait 10 years or 15 years for indefinite. If today your child born in 2020 is 5 years in the UK, then your child can apply for indefinite. And once your child applies for indefinite, you can then apply for 2.5 on the basis of your child. So the good news is that children born in the UK can apply for indefinite leave to remain after 5 years of living in the UK. This has changed from the previous limit of 7 years. The 10 years apply to those who want to apply for registration to become British citizens if the child was born in the UK and has lived in the UK. So that is the position. This does not apply to children born abroad and brought into the UK. They can apply for 2.5 after living in the UK for 7 years. So this change is for children born in the UK under
Well,
their
I'm
long
really
residence.
glad that you pointed out that children born outside of the UK can apply for limited leave to remain in the UK, because that was my next question actually, to ask if the child was born outside of the UK but lived continuously in the UK for 7 years after they were born. So it means that in that situation, they would have to apply for limited leave to remain rather than going straight for indefinite, isn't it?
Yes, and the catch also is this, that if you look at the nugget, the last sentence of the first paragraph says that instead of what? The
Standard
standard
10
10
years for
years
adults.
for adults on private life. Obviously, we are not discussing the adult component. This is for
For children.
the children. Now, we know that under paragraph PL 4.1 of Appendix Private Life, if a person has ceased to be a child, then the person is ostensibly 18 years and above.
Mm-hmm.
Because at 18, you cease to be a child. So if somebody is between the age of 18 and 25 years, before they attained the age of 25, if they have lived in the UK for half of their age, they also qualify for private life limited leave to remain. That
Mm-hmm.
is not indefinite. Because if a child is 8, if somebody is 18, they are no longer children
Okay.
anyway. So whilst we are having this conversation, somebody may ask, right, lawyer, I'm now 24 years. I came to
Mm-hmm.
the UK when I was 12 years old. My parents' visa ran out, and since then we have all been overstayers. Can I apply under my private life? Yes, you can, because if you are 24 years today and you came to the UK when you were 12 years, then that is half of your age, isn't it?
Yes, that's half, yes.
And if you are between age of 18 and 24, and age of 18 and 25, and you've spent half of your age in the UK, then you qualify for 2.5 under appendix private life, similar to a child who was born abroad and brought to the UK and has lived for 7 years. So that one would be still a child under 18. So if you are still a child under 18, you have lived in the UK for 7 years and you were born abroad, then you qualify for 2.5. If you are a child born in the UK and you have lived in the UK for 5 years and you are still under 18 years, you qualify for indefinite. If you are a child born in the UK and you have lived in the UK for 10 years of your life, you qualify for citizenship registration. Then, so these are the parameters. Then, if you are a young adult who has just gone past the age of childhood, 18 but not 25, you qualify for 2.5 under private life if you have lived half of those years in the UK up to the age of 25.
Well, so for all these calculations, you know what I'll advise you? It's best for a layman to give their work for an artisan to do for them. So contact BWF solicitors or your solicitors for them to help you through this. They will explain the situation, the scenarios, and also open up the options for you. BWF solicitors, 214 to 218 Tottenham High Road, Seven Sisters, North London. You can call them on 0208 493 7340. And as I said, you can visit them on the fourth floor of the other house Monday to Friday between 9 o'clock in the morning and 6 p.m. in the evening. Speak to them, allow them to help you speak and open up your situations to them, and they'll give you the options. Because, as lawyer said, we'll sit down with you and assess your situation and then open up the various options that you can have. Because since July 2025, more children and young people can now apply for indefinite leave to remain after 5 years of private life route, being on the private life route, really. And you're doing this instead of the standard 10 years for adults on private life route. But the caveat here again is children born in the UK can apply for immediate settlement under the private life route if they have lived continuously in the UK for 7 years since birth without lawful residence. BWF solicitors helping us bring you the community and the law. We'll be right back and we'll get into our discussion after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Live on BWTV at BWF Solicitors Facebook, at BWF Solicitors YouTube, at BWTV Facebook, at BWTV YouTube. And those of you who have joined us, let me see, to welcome you before we go to our discussion. Sandra Fraser, as usual, is here. Sandy, yes, good afternoon. And you say welcome to our social media program, so to speak. We're thrilled you are here. If you find our content helpful, please don't hesitate to share it within your network. Your shares help us reach more people and build a stronger community. Thanks again for joining us. Thank you, Sandra, for doing this for us. Next, we have Sandra, as you have joined us, Frank Menaba Icon. There's Safo is here saying good afternoon to everyone. We next have Odesheba Kwame Fripon, who's watching with us. Thank you, Odesheba. You can also put in a comment down there and I'll read it out for you. Joseph Benson, Denis Osei, Errol, Prempe, and Kwame to appear. All of you are with us down there in the comment section below. Thank you so very much for joining us. This afternoon, as I said, we're looking at British citizenship for children. British citizenship for children. What are we looking at? What are the options? What are the requirements? As I mentioned, Lawyer Charles Asma is here to help us in on this one. You mentioned in your introduction, Lawyer Asma, very interesting one, that you want to be a royal of the British Kingdom. So you would need to have that right conferred on you. Who qualifies? How do we do it? And what do we need to do, get, and meet before we can do this? I guess it summarizes the various questions that I need to ask, isn't it?
It does. It does. Yes, it does.
Right. So then, what comes over to you again for you to just unpick them and help us to answer these things. Who qualifies? What do we need to have? And what steps we need to take? Lawyer.
Thank you very much. Yes. So today's conversation is all about children. We are going to set the parameters. The law under consideration is the British Nationality Act of 1981. The law is clear on who becomes or who qualifies as British citizen
Mhm,
and how does somebody become a British citizen. Two spectrums. First, we are looking at automatic citizenship. That's gateway A. Gateway A. Call it gate A. So just like at the airport, go to gate A for your
mhm,
boarding. So gate A, automatic boarding. Gate B will be registered boarding or registration to citizenship. Gate A or Gateway A is for those who were born and at the time of birth, mother or father was a British citizen or had indefinite leave to remain. Had indefinite leave to remain depends on whether the child was born in the UK or not. So a child born in the UK where both parents had indefinite leave to remain, and also a child born abroad where the father or the mother is British and whether marriage was in motion or not. So if a child was born in the UK, both parents or one parent was a British citizen or had indefinite, the child is automatically British. Such a child must not be registered to become a citizen, but the child is already a citizen. That's
mhm,
automatic citizenship. Then we have those who were born outside the UK to parents who were British, or a child who was born in the UK, but at the time the parents or both of them or both of them had not attained indefinite leave to remain status, and later they attained. So those are the things we are going to be looking at. But the key law, as we have cited, is the British Nationality Act of 1981. We are looking at the casework guidance for Home Office staff of 7th of August 2025, version 17, which requires that the caseworkers must follow this guidance. So what we are going to do is to ask producer to share the second resource. The second resource that is the case working guidance for staff, and also the first resource, which is the law itself. Each of them are really useful for our discussion. So, producer, take us to the casework guidance for the staff,
okay.
please. Right. If you can zoom it out a bit so that those of us who wear double eye can, oh, is that out or in? Then we'll zoom in then. Okay. Right. Thank you, producer. All right. So, Brakoku, this was published on the 7th of August 2025.
Yeah.
So, how many years old?
Oh, it's a couple of months old.
Very good. So fresh, isn't it? And this is
Very.
version 10. So if somebody is making an application to register a child, this is the document that will be used to assess the application, whether to grant or refuse.
Okay.
So this is the marking scheme.
All right.
Now, there are different sets to this. We have those born in the UK, those born outside the UK. So we look at children born in the UK, which sections apply? Children born outside the UK, which sections apply? Children born on or after 1st of July 2006, which sections apply? Children born to surrogate parents, that is, if we have time, we'll delve further into that. But we are going to discuss up to the point we look at 1st of July 2006, and that is before, on or after, or after. Before is different, on or after is also different. So we look at both areas. So let's start with those born inside the UK. And let's go to page 9. Producer, page 9.
So we go to page 9 of this
And,
document.
and even before that, please, producer, go back. Let's have the context. Back, yes, back to the top. Good. So, Bragoku, if you look at the content page, have you
Mhm.
seen children born in the UK?
Yes.
Yeah. So, producer, just go down a bit. I'll tell you where to stop. Keep going, keep going, keep going. Yeah. Go up. Sorry, sorry, sorry. Too much. Get to the point where we see born in the UK at the top. That should be what we want to see. So, just 2 steps down, just a little. We want to see born in the UK. No, no, no. So should I say up or down? Yeah, keep going up a bit. Go up a bit. Go up a bit. Up to children born in the UK. What I want to see is that I want us to see all the sections. So born in the UK, you can see that we have to go a little down so that we can. So just go just a little, please.
So we're looking
All
at
right.
children born in the UK, starting from page 9,
Yes, but all
going
the
to,
sections that we are going to refer
yes, so
to.
all the sections we're looking at
Yeah, good.
requirements for registration under
Good.
section 1.3,
Yes.
evidence required under section 1.3, requirements for registration under section 1.3a, evidence required under section 1.3a, requirements for registration under section 1.4. Then we also would look at evidence required under section 1.4, parental consent for applications under
Okay, so that
1.3.
one we are not even bothered. So you can see
Okay.
that there are 3 key areas: section 1.3, 1.3a, and 1.4
Yes.
applications. So when
Now,
somebody says, I
let,
want to
let, let
make
me
an
ask a
application,
quick question here before we go in. Now, on the screen, we have requirements for registration, evidence required. Those two keywords keep repeating themselves, requirement and evidence. What's the difference?
right? Requirements. So let's see that those who qualify to enter the room,
Hmm.
those that's the requirement. And when you qualify to enter the room, you must carry your evidence of requirement.
Okay.
Are you with me? So
Okay.
it's not enough to say that I qualify. It's more important that you produce the evidence that you qualify. That's why each
Okay.
requirement has evidence to show.
Okay.
Is it clear now?
Yes, it is.
Good. So, because we are only interested in the various requirements, of course, if you qualify, you claim you qualify, then you must produce the evidence. So, we are not interested in the evidence at this peripheral stage. We'll go further into that. So, section 1.3, section 1.3a, section 1.4, because we are looking at options and requirements, isn't it?
Yeah.
So, we have a section 1.3 option. You can apply under section 1.3. We understand what that means. You can also apply under section 1.3a. What is the difference between 1.3 and 1.3a? We'll get to know. Then you can also apply under section 1.4. Then you can also look at discretion to allow excess absences in the UK for first 10 years of a child's life. Because a child may be 10 years in the UK, but out of those 10 years, they have been spending half of it outside the UK.
Yeah.
Does that excess absence affect the ability of the child to apply based on 10 years, for example, under section 1.4? So these are the things we'll be looking at. Then we'll move on to those born outside the UK and we'll sum it up. All right. So now that we have understood it, we are starting with section 1.3. So take us to section 1.3,
So
page
that
9.
will be page 9 of the document, and
Yeah.
it's talking about requirements for registration under section 1.3.
Yes. So option 1, if you want to apply for your child to be registered as British citizen, one option is that you want to rely under section 1.3 to apply.
Okay.
What is the requirement? The list.
So they were born in the UK.
One,
They
born in the UK.
Yes,
Two,
they were not British citizens at birth because at the time neither parent was a British citizen or settled.
good. So if one parent was settled or had British citizenship, then the child would have come under Section 1(1), which is automatic citizenship.
Okay.
And therefore, you don't have to register somebody who is already a citizen.
Okay. Yeah.
That is why. So that means we know that for you to apply for citizenship, you were not automatically a citizen because both parents or one of them wasn't settled or had citizenship. Point three. So
So
requirement
while
three.
they are minors, either of the parents has since become a British citizen or settled in the UK.
Good. So one parent has now become a citizen or has indefinite leave to remain, and you want to register the child.
Okay.
Number so these are the requirements for children who were born in the UK. By the time the child was born, both parents were foreigners, and none of them had settled.
Okay. And the other one says they are under the age of 18 on the date the application is received.
Good. So if the child is over 18 or 18 years, then this cannot be because this is registration as
Mhm.
a citizen when you are still a child.
Then on the final point, they are of good character if aged 10 or above. And I would obviously ask, a child and good character, what would they have to be doing? They are just 10 years.
So it says that so you can see that there is a proviso there.
Hmm.
The proviso is that if 10 years, what the law is saying that if you want to become a British citizen and you are 10 years, you must be of good behavior. If
Okay.
you are not under 10 years, we can pardon you.
Hmm.
Yeah, if you are under
So,
10
so,
years,
so what do we say good behavior is?
that is anything under suitability, criminal behavior, anything
Hmm.
that, of course, if you're a child, you cannot be caught on drink driving or driving offenses of anything. If you are a child, but it could be some behavioral issues to do with a child. Children can commit criminal offenses of any nature. And so, if you are a child and you have committed an offense, then that can be an issue because your character might be at stake. So, when it comes to debt, when it comes to those aspects, if you're a child, there's no way you are going to owe anybody. There's no way you owe IHS and stuff like that. But if you're a child, it's possible that you have committed assault upon another child or even an
Hmm.
adult, true or false,
Okay. Yeah, it could
and
be.
such matter has gone before the court, magistrate court or crown court, and is being looked at. Whether you were sentenced with in absentia or sentenced with convicted and sentenced community punishment or anything, or because you are a child, you've been pardoned, but the sentence is there, then that would be a good character matter.
Okay. Registration under Section 1(3) gives British citizenship other than by descent. Could you also clarify that for
Yes.
us, sir?
So other than by descent, so here you are registered. So by descent are the people who are taken after their parent. Let's say you have naturalized in the UK and you've given birth. Once you give birth, your child takes after you, right?
Hmm.
So that is the line of descent. That what we call the family tree.
Okay, so then it would be myself, my offsprings, my offspring's offspring, but not cousins, nor
Yes, so that,
nieces.
that line because you can give your right to somebody, but if I'm a British citizen and I give it to my child cannot give to his child because my child took from me.
Hmm.
That's why I say otherwise but than by descent. So when you are registering the child, what we are saying that at the time you were born, your child wasn't British. So when you became a settled person or when you became a British citizen, you are asking for the child to be considered. So the
Okay.
child is going through the mill, right?
Hmm.
Themselves. And that's why he's saying that this is otherwise than by descent. So it's not like because of your family heritage, you are getting this. Because the descent under section 2 is a different conversation. So
Okay.
that is why it's otherwise than by descent. So when somebody is registered in this way, you see that on the British citizenship or nationality certificate, they write registration under section 1.3. If it's an adult, they will say registration under section 1.6,
Okay.
and so on and so forth. So if you ever have sight of a British registration certificate of a child, you see the option under which the child was registered listed there. All right. Now
Okay.
we move on to what does this person need to show in terms of evidence? What do they
So
need?
obviously, then it comes to the question I posed earlier on, where there is the requirement. But when you have met the requirement, you need to evidence that you meet the requirement, isn't it? And that's what we are going to look at.
Very good. So, Brago, we are not even going to look at the evidence requirement they have set out there. Let's go back to the requirement and see if we are assessing this as case workers, whether we can pick it up. It says these are the requirement, and each requirement must be evidenced, right?
Mhm.
One, they were born in the UK. What is the evidence?
So I need a birth certificate
Very good.
and
Ticked.
the red book.
And the red book, that is if we want to add more to it. But birth
Mhm.
certificate suffices to show that it's a British birth certificate indicating parents' names.
Okay.
Then we go to
The
requirement
two, they
number
were
two.
not British citizens at birth because at the time, neither parent was a British citizen or settled. So evidence of the parents' status in the UK, isn't it?
Very good. And that will tell whether if the status was before the child was born, then we don't have to register the child if you know what you are doing.
Mhm.
You just tell them that hang on. At the time your child was born, you had indefinite leave to remain, EU as a settled status. So your child is British. Just get a passport.
Mhm.
So it's important that we are looking for, so we compare the birth certificate and the nationality of the, no, the immigration status of one of the parents registering the child at this stage. Then we can compare which came first. If birth certificate was there before the settled status or indefinite of the parent, then the child falls under 1.3 because at the time the child was born, neither parent had. And while the child is still under 18, one parent has become settled. So we need the status of the parent who is registering the child. Next.
The next one is while they are minors, either of the parents has since become a British citizen or settled in the UK. So evidence of the status of the parents, isn't it?
And we have that already under requirement B. But I say while they are still minors. So we are now going to compare the birth certificate of the child and today's date. Well, we are making the
Mhm.
application today. If birth certificate and today's date indicate that the child is still a child under 18, then that is the point.
At the
While
point.
still a minor, one parent has become settled.
Okay.
So that if the parent has become settled, but we've just realized that the child has turned 18, then that will not fall, the requirement 3 will not be met because the child is still not a minor, even though the father or mother has gotten indefinite status.
Oh, okay. So then the next one would still be the birth certificate of the young person because then the child should be under the age of 18 on the date the application was received.
Very good. You are there. Well, fantastic. You've been a good caseworker.
Mm.
Next.
Then they are of good character if aged 10 or over. So if they are, say, from 11 up to 24, 25, where they are full-fledged adults, then we're looking at whether they have any criminal convictions, any suspended sentences, and all the things that would go against the general public good, isn't it?
Very good. So in this case, because we are looking for specific evidence, the question you are going to ask the person is, one, because it's from 10 years going, so you know the age as we speak. Then
Mhm,
you ask them, has your child been involved in any criminal issue that has gone before a magistrate judge, court judge, or a crown court judge? What
mhm.
was the outcome? Can we give us a copy of the sentence or the decision? That will determine whether the child will have a good character consideration or not.
Mm. Okay.
Yeah. So these are the evidence. So you can see that we don't have to go to the rest because we've been able to identify all the
What
evidence. So the
evidence
evidence
that
so
we need?
far birth certificate, parents' settled status, indefinite leave to remain or citizenship, and also the child's own behavior, isn't it?
Right.
Yeah. All right. So we move on. So we've done option one, registering a child after you have gotten your indefinite and the child is still under 18. Let's go to option two. When we are looking at options, so option two is 13A, page 10. Page 10. Yeah, that's it.
Okay, so this one is talking about requirements for registration under Section 13A, and it reads children are entitled to registration under Section 13A of the British Nationality Act of 1981 if they were born in the UK on or after 13th of January 2010. They were not a British citizen at birth, as at the time, neither parent was a British citizen settled in the UK or serving in the UK Armed Forces. The other requirement is that children are entitled to register if, while they are under the age of 18, either parent becomes a member of the UK Armed Forces, they are the age of 18 on the date of the application, and they are of good character if aged 10 or over.
So let's delve into this.
Mhm.
First requirement is that if you want to apply under 13A, that means you don't qualify under 13 itself.
Yes.
So under 13A, child again born on or after January 2010. So you see here there is what? A specific age date requirement on
Mhm.
or after. So a child born on or after 13th January 2010 will be looking at, okay, a child born on January 2010, how many years would the child be now? About 15
So
years, right?
15 years going to 16.
Yes, 15 going to 16. So you can see that's still a child.
Mhm.
But there are other factors. They were not British citizens at birth. At the same time, because at the same time, neither parents. So the same as 1-3, isn't it?
Yeah.
Yes. Then again, we go to the third requirement. They were under the age of 18. Neither parent was this or that. So here we are bringing armed forces into it.
Yeah.
Then we go into they are under the age of 18
On
on
the
the date
date of
of
application.
application. So still a child then. They
Mhm.
are of good character if aged. So what is different from 1-3 and this one is the point one, isn't it?
Yeah. The date.
Because one says that they were born in the UK on or after. The other one says that born in the UK, full stop. But this one says born on or after. So if the child was born in the UK in 2009, then the child will not come under 13A. It will come under 13.
Mm.
So 13 is open, no date requirement. But so if a child was born on or after, could be that maybe the parent was a student and in the UK then, and the child was born. But the child had not been born in 2009. So these are children from the age of 15, 16, 17, and nearly 18 years, isn't it?
Yes.
All right. So these are the things we are looking at.
Okay.
Age
And
specific.
you would also realize, if I'm right, the evidence under Section 13A kind of similar to the ones we looked at in Section 13 itself.
Yes, so to speak. So if you look at the specific, it says evidence required under a 313A, child full birth certificate, isn't it?
Yes.
Which who shows what date?
Born on or after the 13th of January.
Good. So if somebody comes to me with a birth certificate of a child which is dated 13th January 2009, I would say this will not, the application cannot be made under 13A. It will be made under
Under
13.
13.
Good. So these are the specific requirements. And also the evidence of parents' service in the army. These are the armed forces. A
Mhm.
letter from the Ministry of Defense. These are also for the armed forces. So you can see that 1 and 1-3 and 1-3A are similar, except the specific date the child was born.
Who was born in? Okay.
All right.
So then
So that's
we can conveniently look at section 1.4. What would be the
exactly.
significant difference in here?
Okay, so 1.4. What does it say? 1.4.
Well, the guideline says children and adults are entitled to registration under Section 1.4 of the British Nationality Act of 1981 if they were born in the UK. They were not a British citizen at birth, as at the time of birth, neither parent was a British citizen or settled in the UK. If they are aged 10 years or over on the date of the application, they have lived in the UK for the first 10 years of their life. They have not been outside the UK for more than 90 days in each of the first 10 years of their life. And the Secretary of State is satisfied they are of good character.
So this is a standard one we know, where when your child is 10 years in the UK and they were born in the UK, you want to register them. So that's the standard section 1.4 that we know.
Okay.
So that is the private life of the child. So registering the child based on his or her private life. So
Yeah.
normally we say that, oh, your child is 10 years. You can apply for the child to become a British citizen. That's what we know, isn't it?
Yeah. Okay.
But these are the requirements. And that is why I say that for such children, good character is important. And that the Secretary of State must be satisfied that they have good character.
Right. Well, ladies and gentlemen, if you just joined us, we are live on the Community and the Law, live on BWTV, brought to you by BWF Solicitors. You can get us at BWF Solicitors, both Facebook and YouTube, and at BWTV, both Facebook and YouTube. And we're discussing British citizenship for children, options and requirements. We have delved into some of these things. We've looked at the requirements, look at the basic evidence items that you need to provide. What will be the next steps? And how do we go around and about it? Lawyer Charles Asma from BWF Solicitors is with us. Listen, if you have any legal issue, interpretation, application, appeals, family matters, when it comes to immigration matters and all the other bits, business support and advice, investments, and all the bits when we need a lawyer, you have to trust BWF Solicitors, located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. If you go by public transport, you need the Victoria line to Seven Sisters. And when we get out of the train, use exit number 2. That will bring you to the frontage of the Anna House. Climb up to the fourth floor. You will see BWF Solicitors. They are there Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340, 0208 493 7340. In emergency situations, 077 127 61884. And you would have the confidence to give this testimony as our dear friend Matt gave and was talking about how she was properly served when she brought her stuff to BWF Solicitors. And I'm saying thank you very much, BWF Solicitors, especially Abigail Jan, for assisting throughout their application for a successful result. We're taking a break and saying thank you to BWF Solicitors. And when we come back, we'll go back to Lawyer Charles Asma for him to help us continue with our discussion. I don't think we can add a quiz, so that's good.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are back live with you on BWTV. Gilma Hagan, can we ask questions? Yes, your questions are very welcome. So put them in the comment section down below. You are with us on Facebook, so you can go to BWF Solicitors or BWTV UK. Leasma is still here, and we're looking at British citizenship for children, the options and requirements. I asked him earlier on to get us to look at the requirements bit and the evidence bit, which he's taking his time to explain to us. And we're not doing this in a vacuum. We're looking at the guidance that caseworkers use, and that's what's helping to get us to understand what it is that we need to do. So, last one, yes, we've looked at section 1.3, 1.3a, and 1.4. How do we kind of pick that and work with it so we can make a successful application?
So far, we've been looking at children born in the UK.
Mm-hmm.
We are going to look at it is okay. We'll be going to look at children born outside the UK, but let's go back to children born in the UK. What about under any of these categories? The child was born in the UK but was sent abroad for whatever reason, has been living there for 1 year or for 8 months, and we want to bring the child back. Can we still bring the child back and apply? So the guidance makes provision for excessive absences from the UK for a child who is seeking to apply under any of the options outlined. Option 1, 1.3. Option 2, 1.3a. Option 4, 1.4. Option 4 is for children who are a little, let's call it mid, a little close to 18 years, where they have to show good character. And so their criminal conduct is important. 1.3 could be anybody. 1.3a are children born on or after 13th of January 2010. So the age is of importance, or the timing. What about a child born here, sent abroad, brought back, timing? We put all this together, but there have been absences because it's lived in the UK. Where there's continuous residence for 10 years, does absence matter? Yes. How much level of absence? Can there be exception? What if it's too excessive? What do we do? Let's go to page 10. Oh, sorry, 11.
Okay. So we're looking at page 10 of the guidance document that will be
Page 11.
Yes, we're looking at. So it talks about, yes, if you pull it up a bit and click on page 10 first, requirements
Page
for
11.
registration.
Page 11.
Page 11 it should be. Parental consent for applications under 1.3, 1.3a, and all that. A person has
No, we are skipping the parental consents because we know that in all these applications you need parental consent. So that's fine. But we are looking at again page 11, the same page 11, but it says go
we
up,
haven't
up.
come to born
We
outside the
haven't
UK
come to
yet.
one
We're
outside.
still
We are
on
looking
born
at
within the UK.
exceptions for absence. Exceptions for absence. If you go to the checklist, yeah, the table of content, exceptions, discretion to allow excess absences. Have you seen it?
Yes, so the second page 11 that we click on that. Okay. So it says
Good.
discretion to allow excess absences in the first 10 years of a child's life. And I read, it gives discretion to allow absences of more than 90 days in any one or more of the first 10 years of a person's life. You should normally waive excess absences if the number of days absent from the UK in any one of the years does not exceed 180 days, and the total number of days over the 10-year period does not exceed 990 days.
Please,
Then again,
Brakoku,
okay.
let's convert 180 to months so that it will be easier for people. 180
So
days is how
182
many months?
months on the average
That's
is about
6
six
months.
months.
6 months. Now divide 990 by 180. What do you get, please? Calculator. And viewers and listeners, you can do this with us.
So
Just pick your phone.
990 divided by 180. Let me get to my calculator, and this is 990 divided by 180, and that gives us 5.5 months.
Okay. So all this somebody will ask, can we break it down simply? Okay. We know that 1 month is 30 days, isn't it?
Mhm.
So 990 divided by 30, what do we get? 990 divided by 30. So cancel, cancel. That's 11 months, isn't it?
11 months, yes.
11 months. So what? So keep it in months. It says that in the last 10 years, up to the date of application, the absences should not go beyond 11 months.
So we're talking about in the last 10 years, you shouldn't have stayed out of the UK for about a year.
Yes, for about a year. Because
Yeah.
therefore if the child has been sent away, lived in lived abroad for 2 years or for 1.5 years, and we are bringing the child back, can we still say that the child was born in the UK, has lived in the UK for 10 years, so we are registering the child? These are the exceptional discretionary considerations when the child has been absent for a little longer than the standard time. The standard
So let me then
absence.
ask. I know. Sorry for cutting you. That was quite rude, but forgive me.
No, that's okay.
If the child has been out of the UK for, say, 10 years within the 10-year period we are looking at, but for every year the child is away for just about a few months, are we going to look at the cumulative number of months that they have been away, or it has to be continuous within a period?
Okay, now let's go to the second point under the exceptions. If the number, what does it say?
So
If no, no, that yeah. The first one is 180 and 990. The second point,
the
the
number
bullet
of
point.
days absent exceeds 180 or 990 respectively, but was due to circumstances beyond the family's control, such as serious illness.
Good. So if the point you are raising is to be considered, then it will be considered under exceptional grounds.
Okay.
And exceptional grounds will be that serious illness. Because if you are telling me that in each year they've been away for some months, what is some? Let's define some as 3 months. And if the 10 years, every year they go away for 3 months, then 10 times 3 is 30, isn't it?
Mm-hmm.
30 is more than 11, which is the maximum absence for
Yeah.
of 990 days. So 30 months will be 339. So looking at this, we are likely to then say that, hang on, it appears that the child has been away for more than 990 days. And if the child has been away for more than 990 days, then we have to look at why they stayed away for that long.
Okay.
Is it illness? And what is the consideration for excessive absence beyond the limit? Illness, isn't it?
Yeah.
Apart from illness, what else?
Um.
Somebody will say, well, what about bereavement? But if the
Yeah,
child is
it could be,
bereaved,
but bereavement wouldn't take you for more than 30 days.
very good. So somebody can we can stretch the argument. Illness is whose illness? Is it the child's illness or the parent's illness?
We're obviously looking at a child's illness, isn't it?
The child's illness is what is actually preventing the child from entering the UK or returning to the UK. So can the child then say that bereavement, if the child is bereaved and it is on their own bereavement, quote and unquote, then the child then is not even alive to be able to pursue this argument. So bereavement can only be bereavement of a family member, isn't it?
Yeah.
But if a family member is dead, what business extremely has that got to do with a child who is bereaved? Because if unless we say that the mother or the father is dead, and during the period of funeral and all those things, it took them that long. But will it take about 30 months, 11 months? No.
No, it
But
wouldn't.
illness and serious, that's why there's adjective of illness. What sort of illness are we looking at here? Serious illness. And if it is serious illness, it will not just be one day or 1 month. It will be a continuous or prolonged period, isn't it?
Yeah.
Then this might be corroborated by evidence of the consultant or the medical doctor who has been attending to the child as far as the treatment is concerned. So if we are going to argue that my child has been away longer than expected, but it's because of illness, then you've got to prove it because that is your case to prove. And so, yes, it's possible. However, it then takes you to a threshold of proof, and that burden is always yours as a parent. So, please, if you are considering registering your child when they are when they are 10 years old or 11 years old, please check how long they've been away for and bring them back as quickly as possible so that they can live the time and make it up so that they don't get caught up when it's too tight and last minute.
There's one very interesting paragraph there on the page that we have on the screen. And the guidelines is telling the caseworker not to waive excess absences over 180 days in a single year or 990 days in the 10-year period, where the only reason was that the person or their parents were unaware of the requirements without there being any special circumstances. And then the parents' absences with the child were entirely voluntary. That's very interesting, isn't it?
Yeah. So what is voluntary absence? Voluntary absence is that we went on holiday. That's voluntary, isn't it?
Mm-hmm.
We were having family meetings. That's voluntary. We were building mansions. That's voluntary. I was celebrating my birthday. That's voluntary.
Mm.
I was attending my mother or father's 10th year anniversary of death. That's voluntary. So the only thing that will make sense is where it touches the heart of the child, him or herself, illness. Anything
Okay.
else is volunteered, and that is optional. So where it is volunteered, or you volunteer to be away longer than required with your child, or you send your child away, forgetting that there is a project ahead, which is the registration of the child with these serious requirements, then you cannot blame anybody. And it's clear, exception is serious illness and must be proven.
Serious illness and must be proven. Lawyer Charles Asma is helping us look at um, British citizenship for children, the requirements and the evidences that we're looking at. Yes, we've touched on children born in the UK. I would want us to, as we go along, but remember, if you have a question, you can text it or put it in the comment section below at BWF Solicitors, both on Facebook and YouTube, or text it to 07399 That's why if a person was born outside of the UK, 13A, 13, and 14, do they apply to such children?
Right. So we are going to children born outside the UK. Before that, let me make this correction. Remember when we were converting the 990 days into months,
Mm.
there was a miscalculation. We said 11 months, right? That must be 33 months, actually. 33
Okay.
months.
All right.
So if a
That's
child
fine.
has been
Thank you.
away for 33 months, then that is long, long, long in 10 years. But the point you raised was 30 months. 30 months is within 33 months. What if the child has been away for more than 33 months? Let's say 1,000 days. That's extreme absence.
Extremely long. Yeah.
Yeah, because it says the minimum is 180 and the maximum 180 in a year and 990 in
90
10
over
years.
the 10-year period.
Exactly. And we converted 990 into 33 months. And so if the child has been away for 33 months in 10 years with all the holidays put together, that's fine. But if it goes beyond 990 days, which is 33 months plus 1 day, then it goes beyond the maximum required. In this case, you must show serious illness. Why the child was more than three months
Months
absent.
away. Okay. All right. So then I think it opens the door for us to look at the bit where the child was not born in the UK. Lawyer.
Yes, so producer, this time we are going to look at a child born outside the UK. What Quite a lot of us have children born outside the UK, and we intend to register our children, or the
Mm-hmm.
children um, is in to be registered and all that. What are the options? So far we've captured three options. We are looking for the other options. So the next option is at page 14, page 14 under section 3.5, under section 3.5.
Mm.
So page 14, what are the requirements under 3.5?
Okay.
One.
So children are entitled to registration as a British citizen, sorry, under Section 3.5 of the British Nationality Act of 1981 if they were born outside the UK. At the time of the birth, they had a parent who was a British citizen by descent. If they are under the age of 18 when the application is made, if the child and both of their parents were in the UK at the beginning of the 3-year period ending with the date of the application, the child and both of their parents have not been absent from the UK for more than 270 days in that 3-year period. The consent of both parents is given to the application, and children aged 10 or over on the date of the application are of good character. Lawyer.
Good. So we are looking at section 3.5 option for a child born abroad. And here one, we want to know the child was born abroad. Insofar as the child was not born in the UK, the child is born abroad. It doesn't matter
Mm.
where or which country. Point two, and that is where this descent comes in. At the time of birth of the child, they had a parent. It didn't say the child had parents. The child had a parent
Mhm.
who was a British citizen by descent. So there is family tree somewhere that we can rely on to benefit the child under 3.5.
Mhm.
So a parent of the child could be the father or the mother, could even be an adopted parent. And that adopted parent had British citizenship through their lineage, family lineage. Then the next one is that the child is under 18. So under 18, because we are talking about children.
Mhm.
So 17, 17 years, 11 months, 29 days, isn't it? That is under 18. Then the child and both of their parents were in the UK at the beginning of the 3-year period ending with the date of application. Let's situate this in context.
Mhm.
We are trying to understand what do we mean by they were in the UK beginning of the 3-year period add to the date of application. Let's say the date of application is today, and today's date is 13th of December 2025. So let's calculate backward 3 years from today. That will take us to 2024, 13th December, isn't it?
Yes.
So 24,
2023,
23, 22.
22.
So 13th of December 2022, the child and both parents
Mm-hmm.
were no, so the child and both of their parents. So here I didn't say both the child and the parent. He said the child and both of their parents. So here we are looking at both parents involved.
Mm-hmm.
The child and both of their parents were in the UK on the 13th, beginning of 3 years, which is on the 13th of December
2022.
2022. If
Mm-hmm.
we are making the application today, 13th December 2025.
Okay.
That's a 3 year period
Prior to
ending
the
with
application as well.
exactly, yeah.
Right. And
Then,
the child and both of their parents have not been absent from the UK for more than 270 days in that 3 year period. So between 13th of December 2022 and 13th of December 2025, the child and both of their parents have not been away for 270 days. So if we look at 270 days divided by 30, 27 is 9.
yeah,
So
so that's nine
um,
months. 9 months.
9 months, yes.
Yes. So within the 3 years to the date of application, both the child and the parents had not been absent from the UK for more than 9 months.
Okay.
Right.
And
Then we go
obviously,
to,
both parents will have to give their consent to the application, isn't
of course, to the consent, which is a standard requirement that they want the child to be registered. And the next one is that if the child is 10 years or over, the good character assessment will set in.
it?
So you can see that Section 1.3, Section 1.4, Section 1.3a for children born in the UK is quite light in terms of the requirement.
Mm.
Section 3.5 is quite heavy. The thresholds are high because it's not just about the child, it's also about the parents' absences.
Yeah.
And exactly, and so on and so forth. And the 3 years, this and the that. So if the child is born outside the UK, you can do so by registering the child if the child is now in the UK. However, you have to meet all these requirements if you want to opt for the option under 3.5 of the law. Let's
Okay.
go to discretion. There is no discretion. Please go read that one.
Well, so there's no discretion to accept a longer period of absence than 270 days in the 3 years before the date of application. So it means that if it's more than 270 days in the 3 years, so in our example, between 13th of December 2022 and 13th of December 2025, if you have been outside of the UK cumulatively for 270 days, forget it.
Forget it. So compare this to the other one. You can see that the other one, they said if there is what? Serious illness, that could be an exception
Yeah,
for children born in the UK and they were sent abroad and they have been brought back.
yeah,
But a child born abroad and brought in cannot be sent away for more than 270 days and still take advantage.
yeah.
So that's the difference. So let's note the difference in absence for section 1.4 and section 3.5.
Okay.
All right.
There's the next step that sounds very interesting. Now it talks about if the child was born before the 1st of July 2006 and the parents were not married, all references to a parent are references to the mother only, unless the child's birth was legitimated by the parents' subsequent marriage.
Good. So this is where a child born. So when we look at section 50 of the British Nationality Act 1981, subsection 9, and section 50, subsection 9, capital A of the same statute, it tells who the father is. Who the father is.
Mhm.
The father is the one whose name is on the child's birth certificate as father. We call it registered father or the named father. Now, if that is standard provision, or the child father is the one who is married to the mother of the child at the date of birth.
Mm-hmm.
So we have legal father and biological father. Biological father is the one who made the baby, but the legal father is the one who
Who's married to the
accept
mother at that time?
who accepts the baby as my father, because my wife went away, played away, and brought in the benefit. So when the mother plays away and brings in the benefit to the married man in that marriage, the child is for the man. That is the provision under 50A 9 and 59A. Now,
Mm-hmm.
this one is saying that what about children who are in that situation, born on or after 1st of July, and there is a mix up, not married, and this and all that? How does that play out? So let's break this down. A child born on or after 1st of July, so it's clear, 1st of July 2006,
Mm-hmm.
and the parents were not married. So this one, they were unmarried partners, or it was a one night stand, or they were in a boyfriend girlfriend relationship, isn't it?
Mm-hmm.
And the child was born because the parents were not married. Not married means that one, the mother was married but divorced before the child was born, or the mother had never been married, or the mother was in an unmarried relationship with the with somebody. All these are not married. And it says that reference to parent is only the mother, not the father. So
Mm-hmm.
mothers are important because under the law, the mother of the child is the one who gave birth to the child. Simple. We are not
Okay.
even looking at who and who. Who gave birth? And who gives birth is clear. 9 months pregnancy, childbirth with all the history and record of birth. And the father, if he satisfies the definition of father. And we have defined father, haven't we?
Mm-hmm.
Under section 50, subsection 9 or subsection 9A of the Nationality Act. So if the child was born on or after 2006, 1st of July, and parents were not married, and reference to father, mother, as we have here, then it says that the reference requirement need to be met only by the child and either of their parents if on or before the date of the application. So this is where we are looking at. So what is the requirement? If a child was born on 1st of July 2006 and the parents were not married, what happens to the child as far as registration is concerned? One, what is the requirement? One.
They said the child's mother or father has died.
Mhm.
The parents, marriage or civil partnership had ended in divorce or dissolution, and
Mhm.
the parents were legally separated on the date of the application.
Right. So, a child, a child has been born, and we are saying that this child father acquired birth certificate, passport for the child under Section 1:1
Mhm,
because the mother divorced that one. Let's say somebody comes to the UK with a skilled worker dependent partner. Once in the UK, the lady has an affair with another man who is
mhm,
British. The child is born, and we want to know the two men, because we see
mhm,
two men here, British man and a foreigner. The foreigner was the one who brought the lady. The foreigner is married, but we want to see who is actually the father of
the
the child.
father.
In this case, we want to see whether at the time the child was born there was divorce or not. If there was divorce or separation, because some people will be separated, but the divorce proceedings would not have ended.
Mhm,
And so the rules say that marriage ended in divorce or legally separated on the date of application, and so on and so forth. So where there are issues, we can look at registering the child using form UKF and so on and so forth, or Form T, and what have you. So these are the exceptions to the standard rule where we are not sure who is actually the mother, who is actually the father, whether the British man. So are you saying that if you take the passport away from the child and the one who brought the woman to the UK is also divorced, and says that you are no longer, I have no business with you. And the law is also saying that the passport for the child shouldn't have been given. Then where does the child sit within the spectrum of the rule? That is where there are exceptions. So we can look at the exceptions and say, no, that is not fair on the child. So we have to find a way to register the child to become British. So there are ways around these things, but we are just going through them methodically. So that's that bit, section 3.5. Let's go to section 3.2, page 15.
Okay. So 3.2 says the law in relation to section 3.2.
Sorry,
Children are
Bragoku.
entitled,
Sorry,
yes.
Bragoku. Please, can you go to just a step up, 3.5 evidence? Because it appeared there was just too much of law. The evidence. So no, that one. Let's go through the
Okay,
evidence.
so
Just go.
the evidence, that's a long list there. Applications under Section 3.5 must be supported by the following evidence: child's full birth certificate showing parents' details, evidence of the parents' British citizenship by descent at the time of the child's birth. If the claim is through the father and the child was born before the 1st of July 2006, the parent's marriage certificate, passports or alternative evidence of residence for the children and the parents to confirm the residence in the UK for 3 years immediately before the date of application. They have not been absent from the UK for more than 270 days in that 3 year period. So your passport and any other evidence to show that, yes, you have not been away for that long. Then we can go on to, if one of the parents has died, the death certificate for the deceased parent. If the parents' marriage or civil partnership has ended in divorce, either the parents' divorce certificate, a decree of nullity, evidence of dissolution of civil partnership, and a decree of judicial separation. So the long list is what you need to have to show that you qualify and you meet the requirements to be registered as a British citizen.
Under what?
Under Section 3.5,
Very good.
children
Because
born
there are a lot of
outside of the UK.
options under this option, 3.5. If you are born outside the UK with this requirement, then you have to show this evidence.
Mm,
Right.
okay.
Okay. Now we go to the next option for those born outside the UK under section 3.2. Under 3.2.
Yeah, so 3.2, and it says that children are entitled to registration of British citizenship under 3.2 of the British Nationality Act of 1981 if they are born outside the UK, either parent, that is the parent in question, was a British citizen by descent at the time of the child's birth, the mother or father of the parent in question, that is the child's grandparent, became or but for their death would have become a British citizen otherwise than by descent, either on the 1st of January 1983 or at the time of the parent's birth.
So here we are looking at extension for children who may have um, family lineage linking them to citizenship. And that's where 3.2 will be relevant to those people. But let's go down and look at specific evidence for 3.2 people. Evidence, documentary evidence under 3.2. So if you are relying on your parent or grandparent
Mm,
who acquired citizenship by descent because they got it through their own parents and so on and so forth. How
mhm.
do you take advantage before 1983, after 1983, before 2006, after 2006? Where do you situate your case? What evidence do you need if for such a child?
So the child's birth certificate showing parents' details, the relevant documentation to establish that the parent in question was a British citizen by descent at the time of the child's birth, the relevant documentation to establish that the grandparent was a British citizen other than by descent at the time of the child's parents' birth.
So
The
so here, let's establish the difference between point 2 and point 3.
Mhm.
Bullet point 2 says that document to establish that parents in question was a British citizen by descent. So parents in question got citizenship through their own parents. In other words, through the grandparent of this child. Are you with
Okay.
me? We are looking at descent, lineage.
Mm-hmm.
So the parent of the child became a British citizen through their own parent.
Okay.
But the grandparent of the child, which is the parent of the parent, became a British citizen not through their own parent. That is point 3.
Okay.
Because it says that the grandparent became otherwise than by descent, but the parent became by descent. Are you with me?
Yes.
So that is point 2 and point 3, where they could be confusing, which is which. So one is for the parent direct to the child, and one is for the grandparent, the second in line from the child, literally.
Right. Yes. Lawyer, I think we are overloading our brains. This a lot of information, but if you
Okay,
may, can I quickly jump a bit, maybe a step or two from where we are and ask?
sure.
We have been able to satisfy all these requirements. We have the evidence they are asking for. We've gathered all of them. Is it then at the discretion of the caseworker to grant the application, or it becomes a tick box exercise because I've met the requirements, I've been able to provide all the evidences? Is there a way they could refuse it?
Well, if you go by the criteria,
Mhm.
then because these applications are checklist exercises.
Okay.
So where it's a checklist, your aim is to meet the checklist. We call them requirements.
Yes.
So if I have met the requirement, let me ask you a simple question. If I have met the requirement that you have prescribed,
Mhm.
does that become a choice for you to refuse or to grant?
Well, to me, as an ordinary person and lay person, I said, no, you don't have any reason to refuse it. But these are technical things, and home office is home office.
I know that is why when you have met the requirement and they say no, we go back and tell them that there has been an administrative error.
Okay.
Either the caseworker did not understand the law and so they have misapplied it. So we are then correcting them and tell them that, my man, this is what he says. You didn't understand. That's fine. I pardon you. I just fixed it.
Okay. So in that case, this application in itself is open to administrative review, isn't it?
That is where the caseworker has not ticked the box, marked the application through the checklist where you
Mhm.
have met everything. But where you haven't met everything, then of course they can refuse you. If you meet it, they shouldn't refuse you. But that's why the guidance is clear that if the person brings A, B, C, D, E as required under this option, you must grant. If you cannot grant, give a reason. So if the reason is flimsy, then it's procedurally incorrect.
BWF solicitors, thank you so very much. You always give us the opportunity to enhance our knowledge and also empower ourselves to be able to, one, understand what the laws are saying, two, what the guidelines are, and three, are also able to put in our applications with a lot of confidence and believing that we will get them right. And of course, you give us the opportunity to learn, especially on this program, the Community Law, which comes your way every Saturday afternoon between 4 and 6 p.m. UK time, as we have done today. And we're live on Facebook and YouTube at BWF Solicitors. Those of you who have questions, those who have concerns to bring up, you can text 07399 208 468 or leave your questions and comments in the comment section down below, either on Facebook or YouTube. We'll be picking them up after this. That's been a lot of information, but it's good for you. It's good for me, and it's good for the community. And BWF Solicitors is so gracious to get us to have that free of charge. But if you need further consultation, you need your application to be guided through with you, and of course, to make sure that you get it right, book an appointment and go to see BWF Solicitors on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340. In emergency situation, 007 004477 127 61884. Now, on the program, you can call in on 0208 493 7345 or leave a text or WhatsApp message, voice note on 07399 208 468. Lasma is here, and I know you have your questions. And of course, Anachi has the first one. One of our colleagues and friends was asking whether you are able to ask questions. Yes, now we're picking them up. So bring that one up and we'll put that before Lawyer Asma to help us. A child born outside UK entered the UK with indefinite leave through his father, who is British. Which section will his application for registration fall? If the mother is not in the UK for consent, can the application proceed? Nanecha Haynes asking lawyer.
Right. So, producer, can you take us to page 19? Page 19 of the guidance.
Okay.
Okay. So, Brakuku, discretionary applications under section 3.1, that's the one Echiahine is asking
Okay.
about.
So then it says that the section explains the circumstances in which it will normally be appropriate to exercise discretion. There are certain scenarios where you would normally be expected to register a child as a British citizen. In all other cases, you must consider whether there are grounds to register exceptionally. And what is the law saying? It says there's a discretionary provision for the registration of a child. The Home Secretary may exercise their discretion to register people as British citizens under Section 3.1 of the Act. And if that will be done if the person is under 18 years at the date of the application, if age 10 years or over on the date of the application, the child is of good character. And we've been asked to see good character requirements, which lawyer explained a bit earlier. Then, if they think they fit to register them, these are the only statutory requirements. The guidance set out how you must normally use the discretion, and I follow slide that lawyer.
Okay, so where the child, so this is one area where the child has been born outside the UK, brought to the UK, and the child could have been given indefinite leave to remain, so they qualified to move on to the next stage. Discretion can be an option for this child. However, the child 10 years and above. What if the child is under 10 years? Then we are looking at one of the parent has become a citizen, a British citizen, or one of the parent is applying for citizenship at the same time the child is applying for citizenship. So Echiahine's question says, the child was born abroad, brought to the UK. The child was given indefinite leave to remain, especially under Appendix EU to the immigration rules, EU 11, indefinite leave to remain. The child has been in the UK for, let's say, 2 years and above, or 2 years more. Can we register the child for citizenship? It says that at the time of registering this child, one of the parents should also be should be applying for naturalization or has already become a citizen. Otherwise, they cannot just register the child. In this case, the child should have attained the age of 10. So we are looking at the age of the child. If 10 and above, yes. If not, again, we have to look at the citizenship status of the father or the mother involved. So there are other things that we have to be looking at. So, Jahin, that is for the first part of your question. The second part of the question says that one parent is not in the UK for consent. There are instances where both parents must give consent, but if the parent registering the child is the only parent with sole responsibility, then that's fine. Otherwise, both must provide consent. How do you do it? You have to send their consent form to the other parent for them to agree for their child to be registered to become British citizens.
Okay, and I think that Chiahine is brought up the saying that the other parent is not the father brought the child under sole responsibility, and I think
Okay, then that
obviously
is your
you picked it
responsibility.
up.
Yeah. So you don't need permission from the other person.
Okay, all right. Well, we keep them coming through. Israel Tete is talking about if you have a visitor visa, do you have to create an account before moving to the UK? I don't know what kind of account are
Okay.
you
Oh,
talking
it's
about,
talking
a
about
bank account or what?
e-visa. E-visa. No, visitors. You are a visitor. You're only coming in to return soon. You don't have to create an account because you are not going to live in the UK.
Okay, so Israel, you don't have to create an e visa account. Frank is asking, I came with a care visa, but the sponsor doesn't have hours, so I'm doing more than 20 hours somewhere. If I want to switch to another certificate of sponsorship, would it affect it?
I mean, it's not switching to another certificate of sponsorship. It's when you are making a new application, whether this will flag up. It depends. The rules say that if you are in the UK as a skilled worker migrant, you must be doing your full time with the main employer and 20 hours with the second employer. So I don't know whether the extra hours you are doing on top of 20, on top of the 20 hours is voluntary. If it's voluntary, that means you have spare time, spare knowledge, spare skill, and you are helping your community. That is not a crime. However, if you are getting paid, you're on payroll, getting paid, that means you are working more than the required extra 20 hours. That can come up and they pick it up. They can make issue out of it.
Okay. All right. Thank you, my friend. So keep them coming through. Let's pick another one. Unisa J is saying, my brother married a Ghana lady with a British passport and had two kids. Her wife didn't want him to join her in the UK for no reason, but rather comes to visit with a kid in Ghana. They are now divorced. What advice would you give them, lawyer?
Right. So, Eunice, even when they were married, the lady didn't want to have anything to do with the man in the UK. How much more now that they are divorced? What can the man do? You see, because yeah, because if, for example, at the time they were together, the woman can say that I want my husband to join me so that together we can look after the children. But that didn't happen. Now that they are divorced, how is he going to enter the UK? Is he going to say that I want to enter the UK to look after my children? But your child has another parent who is doing the job you claim you are coming to the UK to do. The best option would be once he's in the UK, through whichever means. Having arrived in the UK, the law says that because he has a child who is British and the child is in the UK, he can apply to remain in the UK because he has a parental responsibility which is shared with the mother of the child. That's the only way your brother can apply to remain in the UK based on the child. Because her wife didn't want him to join. Now they are divorced, but rather comes to visit the kids. So if he's visiting comes with the kid in Ghana. So my brother marries. Where is the lady now?
Well, I don't think that's clear in there.
Okay, so let's assume it's always. I mean, if the man wants to, if the man is in Ghana and wants to live in Ghana, then this question wouldn't actually come anyway. I'm sure the man wants to visit or be in the UK to join the children. So it's the other way around. Let's rephrase this for this
Hmm.
person. Assuming it's an assumption. We are assuming that the question is that the British mother is in the UK with the children. The British mother is saying that the father can be in Ghana and the children can be visiting him in Ghana whenever she goes to Ghana on holidays with the children. They have divorced now. He wants to know if he can come to the UK to live with the children because he has children who are British? The answer is, if he is able to enter the UK, let's say visitor's visa, and the visitor's visa has expired and he wants to remain with the children, he can apply with based on his direct access. It appears that the lady is happy for him to have access with or to the children, and so that may not be an issue. But what the lady wants is for him to enter first, then the conversation will continue. So, Eunice, let your brother enter first, and the conversation can continue.
Well, we'll take the very last one and then draw the curtains down. And that's coming from Equia. What form should I use for naturalization for my children under 18? And how much will I pay?
There are different forms for naturalization. We have Form MN1. MN1 is for children applying under Section 1.3. We have UK from UKF, those born after 1st of July 2006 with unmarried parents here and there. We have Form T for those who have lived in the UK for 10 years, private life, and applying for registration on their own in their own right. These are different forms for children's applications. But it says that should I use for naturalization? So children is registration, not naturalization. So these are the things. And therefore, I can only point you to the form if you have told me which option you are going to apply under, because we have talked about different options. Whether the child was born in the UK, born abroad, and brought in, the child is applying based on 10 years residence, or the child is applying based on the father or mother becoming settled, and so on and so forth. So my sister Equia, we don't know. Even there's section 1.4, so we don't know which one you want to apply. Please book appointment. Let's have a conversation, dissect the story, your circumstance, then we can direct you to the right form. That is what good lawyers do here at BWF Solicitors.
Well, and BWF solicitors earlier in the week gave us our nugget, which we have put in our pocket and added to our stock of knowledge. Even prior to that, Anama was saying thank you to BWF solicitors, which we'll be doing very shortly. But we said that since July 2025, more children and young people can now apply for indefinite leave to remain after 5 years on the private life route instead of the standard 10 years for adults on private life route. However, children born in the UK can apply for immediate settlement on the private life route if they have lived continuously in the UK for 7 years since birth without prior lawful residence. And we continued with that very insightful and heavily loaded topic of British citizenship for children, the various options and requirements. To be very fair, the guidelines is very lengthy and bulky. We haven't had the chance to go through all of them, but I know definitely you heed to my advice that if you need any further uh, discussion on this one, any further support with this in putting in your application and understanding what the requirements and the evidences are, you will be contacting BWF solicitors on 0208 493 7340. Or you can visit them on the fourth floor of the Underhouse, 214 to 218 Tottenham High Road, Seven Sisters, North London, N15 4NP. But today, we're ending on the note of a summary by lawyer Charles Asma, a resource person and guest from BWF Solicitors on the topic British citizenship for children, options, and requirements. Lawyer.
Thank you very much. So, viewers and listeners, today we looked at options for your children to become British citizens. We looked at children born in the UK and children born abroad and brought into the UK. We said that most of these children may have automatic citizenship and therefore they may not need to be registered. Automatic citizenship falls under Section 1.1 of the British Nationality Act 1981, which states that when or if at the date of birth and when the child is still a minor, both or one parent is settled or has citizenship, the child is automatically British. In this case, you only apply for passport for your child. So when do you have to register? That is when the child is not a citizen and you want the child to become. We looked at option under section 1.3 when the parents have indefinite leave to remain or citizenship after the birth of the child. We looked at section 1.3a when the child was born on or after 13th of January 2010 and all the requirements under section 1.3 apply. In this case, one parent has gotten indefinite and so on and so forth, and the child would want to be registered. If the child is 10 years and above, which in this case, a child born on or after 10th of January 13th of January 2020 would have been about 15 years or less. In this case, such a child will have to show good character because they are 10 years and above. We also looked at section 1.4, discretionary applications. We move on to look at section 3.5, especially for children born abroad. We also looked at section 3.2, children born abroad. We also looked at children born on 1st of July 2006, on or after. We looked at children who were born to unmarried parent. We also summed it up to say that in all this, you have to show the evidence, and the evidence will determine what the caseworker must do. Once you meet the evidence, the caseworker has no business to refuse you because you have met the rules. In terms of application, you can apply using Form MN1, that is, if you meet Section 1.3 requirement, or any other requirement, Form Form T, Form T for children applying based on their 10 years continuous residence in the UK and born in the UK, or Section Form UKF, Form UKF for children born abroad and in the UK, or children born abroad and want to register their citizenship whilst abroad. All these forms are the ones you have to use. However, it depends on the option under which you are applying. So if you are applying under a particular option and use a different form, even though it's a registration form, the form will not be valid because it will not be applicable to the option you have chosen. What it means is that in attempting to register your child, where not sure, seek legal advice so you can get it right once. Thank you.
Thank you very much, Lawyer Charles Asma. It's been very insightful, heavily loaded. But with BWF solicitors, we break it down for you to be able to absorb and consume, and of course, give you the option to further contact them if you need any further support with that. Lawyer Asma, thank you. BWF solicitors, thank you so very much for being there for us all the while. And to you out there, I so appreciate your company, your contribution, your sharing of the page, and also liking, of course, signing on and subscribing to the channel. We will be coming again same time next week. So I will say thank you once again on behalf of my production crew, made up of Sheila Ankara and Padmo Dodu, and my indefatigable producer, Professor Ade. My name is Ulrich Frimpong. Good evening.